In our second part of the doctrine of repugnancy, would like to discuss those important leading cases of the Supreme Court where it was applied. So, in that connection, we would like to discuss the first important leading case, that is Dipchand versus State of UP, Uttar Pradesh. In 1959, Supreme Court Justice K. Subba Rao applied and observed that repugnancy between two enactments can be identified with the help of the following three tests. The first one, whether there is a direct conflict between the two conflicting provisions, and the second test, whether the Parliament intended to lay down an exhaustive enactment on the subject matter and to replace the law made by the state legislature, and the third test applied whether the law made by the parliament and that made by the state legislature occupies the same field. So this was first applied by Justice K. Shivarao of Supreme Court in this important leading case, Deepchand versus State of Uttar Pradesh in 1995. And now we'll discuss the application of these three tests: direct conflict, exhaustive court, and occupy field in another important leading case by the Supreme Court in 1983, that is Worcester Pharmaceutical Limited versus State of Bihar, where the Supreme Court discusses the effect of Clause 2 of Article 254. It was observed that the assent of the President for a state law that is repugnant to a central law or a matter related to a concurrent subject is important, as it results in the prevailing of the state law in that particular state, thereby overriding the application of the central law in that state. So, Supreme Court explained the very effect of Article 254, Clause 2, as the result of obtaining the consent of the President regarding a law made by the state legislature on a matter related to concurrent list would be that the law of the state would prevail over the law made by the parliament in that particular state only. However, the center would always have the final say on whether the state law would hold precedence over the state laws. The state law should prevail over the central law only to the extent of the inconsistency with the law of the center. So, this was the explanation given by the Supreme Court in the important leading case, which is Pharmaceutical Limited versus State of Bihar in 1983, And now we'll go to another most important leading case relating to the doctrine of repugnancy, and that is M. Karunanidhi versus Union of India. In 1979, Supreme Court made the observation that, and it was a landmark judgment on the very doctrine, as in a constitutional bench of the apex court in this important leading case considered the question of repugnancy between a law made by the parliament and a law made by the state legislature. It was observed that the following conditions should be satisfied for the application of the doctrine of repugnancy. So, the first test applied a direct inconsistency between the Central Act and the State Act. And the second test, the inconsistency must be reconcilable. And the third one, the inconsistency between the provisions of the two acts should be of such nature as to bring the two acts into direct collision with each other, and a situation should be reached where it is impossible to obey one without disobeying the other. So the Honorable Court also laid down some prepositions in this respect for the first application of the doctrine of repugnancy. To enactment must contain provisions that are so inconsistent that they cannot stand together in the same field. Repeal by implication cannot be done unless there is a prima facie repugnancy in the enactments. If two enactments exist in the same field and there is a possibility for both of them to operate without colluding with each other, then this doctrine is not attracted. When there is an absence of inconsistency but enactment in the same field creates distinct offenses, the question of repugnancy does not arise. So now we'll go to discuss another important leading case, and that is Kanak Gruha Nirman Sahakar versus Srimati Narayan Ma in 2002. Supreme Court analyzed the provisions of Article 245, 246, 249 and 250 in this connection. So here it was discussed by the Supreme Court relating to this important leading case, that in particular it was expressed by the Supreme Court in this important leading case, and that is relating to Kanak Gruha Nirman Sahakar versus Srimati Narayan Ma in 2002, that as relating to the test of repugnancy, where the legislation passed by the union and the state is on a subject matter included in the concurrent list, then the matter cannot be determined by applying the test of ultravirus, because the hypothesis is that both the laws are constitutionally valid. In such a case, the test to be adopted will be that of repugnancy under Article 254, Clause 2. It follows that it is only when the legislation is on a matter in the concurrent list that it would be relevant to apply the test of repugnancy, as it was held in this important leading case. And now we'll discuss another important leading case, and that is regarding Bharat Hydropower Corporation Limited versus State of Assam in 2004. The Supreme Court expressed that every possible effort has to be made to reconcile the central and the state statutes and to construct them in a manner so that they are no longer repugnant to each other. If the two statutes are not operating in the same fields without any encroachment, then there would not be any repugnancy between the two provisions. So now we'll go to discuss another important leading case, Grand Kakatiya Sheraton versus Srinivas Resort Limited in 2009. It was observed by the Supreme Court that the assent of the President is not just a mere formality. It is limited only to the specific purpose for which it has been sought and given. The state law becomes void with respect to the central law unless that particular conflict was brought before the President for his assent. Thus, the assent of the President does not confer irrevocable immunity upon the law of the state legislature from the operation of the doctrine of repugnancy. So, as it was stated by the Supreme Court in this important leading case, Grand Kakati Sheraton versus Srinivas Resort Limited, on the issues relating to President's assent. And now we'll discuss another important leading case, and that is relating to State of Maharashtra versus Bharat Shantilal Shah in 2008, where the very explanation and examination of the central law relating to Section 5, Section 2 of Indian Telegraph Act 1885 and Section 13 to 16 of the Maharashtra Act of 1999 was examined, where it was observed by the Supreme Court that it is essential to prove that repugnancy should exist in fact. it is important to prove that the state laws are repugnant to each other in the decision given by the court in the issue. In this leading case, State of Maharashtra versus Bharat Santi Lal Shah and others in 2008, Supreme Court expressed that no repugnancy was proved between Section 13 to 16 of the Maharashtra Act of 1999 and Section 5 subsection 2 of the Indian Telegraph Act 1885, which was a central act. So now we'll discuss another important leading case, and that is relating to Jogendra Kumar Jaiswal versus State of Bihar, and which was decided in the year 2016 by the Supreme Court, where it was pronounced that the state law may become repugnant if there is a direct conflict between the two provisions and the law made by the parliament and state legislature occupy the same field, and subsequent legislation made by the state which has received assent of the President of India indisputably will prevail over the Parliament Act. When this exists direct conflict between these two laws, as it was pronounced in 2016 by the Supreme Court. And now we'll discuss another important leading case, and that is relating to Forum for People's Collective versus the state of West Bengal, where it was pronounced by the Supreme Court as regarding the decision as West Bengal Housing Industry Regulation Act 2017 and in conflict to Real Estate Regulation and Development Act of 2017, where the then Justice D.Y. Chandrachud, at present the Chief Justice of India, who found that there was no conflicting provisions in both the laws, and as the Real Estate Regulation and Development Act of 2016, a central act enacted by the Union Legislature, and the subsequent state law, that was the West Bengal Housing Industry Regulation Act 2017, having the similar purpose. So there would be no conflicting provisions and there is no inconsistency found in both the state laws and the union law. And as the union law was made in 2016, so by applying the three tests of repugnancy, Justice D.Y. Chandrachud held void of the West Bengal Housing Industry Regulation Act 2017 17. In this important leading case, forum for People's Collective versus State of West Bengal in 2021. And now we'll go to another important leading case, and that is H.S. Srinivas versus State of Karnataka. In 1987, the Supreme Court expressed that in this connection, that the section 48 subsection 8 of Karnataka Land Reforms Act 1961 as amended in 1974 prohibited the legal practitioners from appearing in proceedings before land tribunals. It was held to be repugnant to Section 30 of the Advocates Act 1961 and Section 14 of the Bar Council Act 1926. So the Supreme Court held that Union List entries 77 and 78 are concerned with the persons entitled to practice before the Supreme Court and High Court, and these entries have been considered as in the particularly leading cases. So it was held in also in some other important leading cases, such as when Mahindra Rao versus Bar Council of Delhi in 1968. So at present in this leading case, also it was held by the Supreme Court as regulating all aspects of the rights of advocates as it was observed in this leading case, H.S. Srinivas versus State of Kerala. And now we'll discuss the ruling of another important leading case, and that is Ma Vaishno Devi Mahila Mahavidyalaya versus State of Uttar Pradesh in 2013. The very test for repugnancy was applied wherever the field is covered by the parliamentary law in terms of list 1 and list 3. The law made by the state legislature would, to the extent of repugnancy, be void. There has been direct conflict between the laws. The direct conflict is not necessarily to be restricted to the obedience of one, resulting in disobedience of the other. But even where the result of one would be in conflict with the other, where the field is occupied by the center, subject to the exception stated in Article 254, the state law would be void as it was held by the Supreme Court in 2013 in this important leading case, Ma Vaishno Devi Mahila Mahavidyalaya versus State of Uttar Pradesh. And now we'll discuss the ruling of another important leading case, and that is Central Bank of India versus State of Kerala in 2009. The Supreme Court observed that Article 254 contains mechanism for resolution of conflict between central and state legislations enacted with respect to any matter enumerated in list 3, which is concurrent list of the seventh schedule of the Constitution. So now we'll discuss another important ruling, and that is relating to doctrine of virus versus doctrine of repugnancy, and in that connection we would like to discuss one important leading case, Odisha Cement Limited versus State of Odisha in 1991. It was observed by the Supreme Court that if the state legislature enacts a law which is not covered by its exclusive list 2, which is a state list under 7th schedule of the Constitution, but relates to a subject included in list 1, which is a union list under the 7th schedule of the Constitution. It is a patent case of ultra virus because of Article 246. It is beyond the competence of the state legislature under Clause 2 and pertains to the exhaustive jurisdiction of Parliament under Clause 1 of Article 246, as it was observed by the Supreme Court in this important leading case, Odisha Cement Limited versus State of Odisha, while finding out the very relation between doctrine of ultra virus versus doctrine of repugnancy. And now we'll go to the very relation between doctrine of pith and substance as far as to doctrine of repugnancy, and in that connection we would like to discuss one important ruling made in 1991 by the Supreme Court in the leading case, State of Uttar Pradesh versus Synthetics and Chemicals Limited in 1991. So, where it was held by the Supreme Court that the repugnancy between two statutes would arise where exists a conflict between the two provisions of law made by the Parliament and the law made by the state legislature are inconsistent. So, also, it was observed by the Supreme Court that the very test of pith and substance has been applied to determine whether the state law has substantially transgressed on the field occupied by the law of Parliament. There is no repugnance where the encroachment is not substantial or the subject matter of the legislation is not the same, as it was held by the apex court in this important leading case relating to doctrine of pith and substance in relation to doctrine of repugnancy in this leading case, State of Uttar Pradesh versus Synthetic and Chemicals Limited. So now we will discuss another most important leading case, and that is Rakesh Vaishnav versus Union of India in 2021, the Supreme Court examined the Farmers Produce Trade and Commerce Act of 2020 also the Farmers Empowerment and Protection Agreement of Price Assurance and Farm Services Act 2020 also the Essential Commodities Act of 2020. All these three acts were to be examined, for which the apex court constituted a committee, and the committee would submit its report before the Supreme Court, and before submission of the reports of examining the acts enacted by the Union Parliament, such as the Farmers Produce Trade and Commerce Act 2020, the Farmers Empowerment and Protection Agreement of Price Assurance and Farm Services Act 2020, also the Essential Commodities Act 2020. So, all these three acts were withdrawn by the central government. So, the case was remain unconclusive, as because these three acts were already withdrawn by the central government. So, in our next upcoming video, we would like to discuss the very importance of the doctrine of repugnancy, also the very limitations on the state legislative assemblies on making laws which, even if are enumerated either under the state list, which is list number 2, and in concurrent list, which is list number 3, as provided under 7th schedule of the Constitution. So the very importance of the doctrine of repugnancy and the very limitations on states we would like to discuss in our upcoming